Hello everybody, it's your immigration attorney Ruiz here with you today to talk to you a little bit more about the adjustment of status process. Now the adjustment of status process, it is the second step in the process for obtaining lawful permanent residency in this country. Now the adjustment of status process comes after family-based petition has been filed on your behalf. And if you watch a previous video, you will understand a little bit more about what I'm about to say. But if you are an immediate relative, that is a spouse, parent, step-parent, or child under the age of 21 of a U.S. citizen, then you can qualify to file your family-based petition, the I-130, and your adjustment petition, the 485, together. You don't have to wait for it. So you file both petitions together. If you are not an immediate relative, you must file the I-130 first, wait for it to get approved, wait until your visa becomes available, and then later, if you qualify for the adjustment of status, file the 485 petition. Now, who qualifies to adjust in the United States? Nobody wants to leave the country if they don't have guarantee that they're coming back. I get it. It's very scary. Most of my clients desperately want to qualify for the adjustment of status so that we can do everything internally. We can handle everything in the United States, and then you get your green card in the United States. So, under the INA, the Immigration and Nationality Act, if you enter the United States lawfully, that is with a visa, most common scenario that I see is that you entered on a tourist visa, you stayed, didn't leave, and then you later qualify for a family-based petition. If you entered the country lawfully, then that's enough for an adjustment of status, and you do get to do everything internally. A variation of the lawful entry process is the Kilantan process. The Board of Immigration Appeals decided a case not too long ago that said that if you enter the United States, if you presented yourself at a checkpoint, an immigration checkpoint, and that immigration officer let you through the checkpoint, even though you didn't have a visa or even though you weren't qualified to enter the United States, if you presented yourself for inspection and somebody let you in, whether it was a wave through or if they asked you a couple questions, not anything that stopped you from being admitted, and they let you in, that's a lawful entry. Kilantan process becomes a little bit difficult because it is our responsibility to prove that we do qualify, that what we're saying is true. So that is why the process becomes a little difficult, because in these situations there's not much proof of that entry. Another way to qualify for the adjustment of status process is through the 245I program. The 245I process is a law that was passed that said that if anybody filed a petition on your behalf before April 30th of 2001, then you can qualify for the adjustment of status here in the United States with a couple of other restrictions. Now, if your petition was filed prior to January 14th, 1998, then all you have to do is pay a $1,000 fee, and then you qualify for the adjustment of status. You get to file that petition and do everything in the United States. If your petition was filed after January 14th, 1998, but before April 30th, 2001, then you do get to qualify for the adjustment status. You do have to pay the fee, but you also have to prove that you were physically present in the United States on December 21st, 2000. Now the requirement is that a petition was filed on your behalf. The requirement is not that it was approved. It is only that it was approvable. That means that they could have approved it even if they didn't. If you think you qualify for the adjustment of status process, or if you want to get started with that process, give us a call. Our office number is 832-390-4664. You can find us on our website at luisruizlaw.com. Our social media handles are Luis Ruiz Law on Facebook, Instagram, and Twitter. Thank you.